the medical expenses of his mother and other expenses of his family dependents. The court observed that even if it is presumed that the wife is getting 20,000 income per month, since the price of essential commodities are reached to sky, the 20,000 is not sufficient for maintaining herself. Respondent being the husband of the petitioner, it is his bounden duty to take care of her. Considering all that, the court had granted an amount of rupees 10,000 and also another amount of rupees 10,000 towards the litigation expenses. Land counsel appearing for the petitioner submits that when the husband is earning more than a lakh as salary and also is having rental income and also other properties, court has only granted an amount of rupees 10,000 as maintenance. And while granting the maintenance, court has failed to consider all these aspects. He submits that the contention that she is working in 3 months is also without any basis. And as per the notice sent to them, sent to the 3 months, where they have stated that nobody is working with the set name. Is it so? That nobody is working with the name?
No, she is not working.
She was working.
She was
Here she was working. Now she was not working. That is the my land's principle.
That Kannada, what is that?
Kannada,
Assessment.
earlier she was working.
She left.
Now she was not working. That is the statement.
It
She
is
left
stated
the
that
job
earlier she-
8 years
job.
ago.
And now she is not working. She submits that considering the financial capabilities of the husband and the fact that the wife is not working, the court ought to have granted a reasonable maintenance under the facts and circumstances of this case. Next, for learned counsel appearing for the respondent husband submits that the MC is filed in the year 2015 before the courts at Mumbai. And later on the transfer petition filed by the wife, it is transferred to the courts at Bangalore. He submits that while while transferring the petition, the Honorable Apex Court has observed that as this is an MC of 2015, it has to be disposed of as expeditiously as possible. It's a case of the husband that wife is not cooperating with the trial. She is not entering into the witness box. He submits that if the wife is successful in proving that what is the income of the husband, or what, and he would be able to elicit whether she is working or not, and whether all the facts that are stated before the court are correct or not. An effective adjudication can be done, and the court would be in a position to pass appropriate orders. He submits that the trial court had rightly granted an amount of rupees 10,000. Next slide. Considering after hearing the counsels on either side, there is a material on that one. According to the husband, the wife is working. According to the wife, she is not working. And according to her, is having his income is more than 1 lakh and is having a rental income of 3 lakhs and other immovable properties. According to the husband, his take-home salary is 90,000 and he has other the loans and other things to be paid. And he'll be getting he will be taking home an amount of rupees 70,000. He has a old mother to take care of. It is when the MCs of the year 2015, even after 9 years, the same is pending. Considering the income of the husband, and as of now, there is nothing to show that the wife is earning. This court deems it appropriate to enhance the maintenance from 10,000 to 20,000. The husband shall pay the arrears to the wife. If the arrears are not paid, the matter will not be taken up by the court for final adjudication. If all the arrears are paid by the husband, within a period of 2 years from the date of clearing the arrears, to the main MC itself shall be disposed of.
In a period of
2 months shall be, that 2 months will
enhanced
start.
period only for these 2 months.
Enhancement is for only 2
Only
months.
2 days. That means 2 months only.
This enhanced amount is for these 2 months. And that 2 months will start, that period for disposal will start from the day you pay all the arrears.
Arrears, please.
Accordingly, the wife shall cooperate and no unnecessary adjournment shall be granted by the court.
That is regarding that enhancement, my lords, that clarification
The
regarding
that enhanced amount is till the application is decided.
from today.
From the date of order till the application is decided by the trial court. Till the MC is decided by the court.
Much ob-
Yes.
Bill number 13. All Krishna take for petitioner.
Yes.
Chair Rajesh Reddy.
Petitioner by me filed the visitation rights, Lordship, the operation portion of order in page 25. My visitation rights dismissed by the trial court on the ground in page 25. Orders 14th. I'll read
Hmm.
the second line. Though the child was very young at the time of incident, a statement was recorded under section 164 of CRPC. The incident of death of mother of the ward will be certainly have impact on mind of the tender age ward, and till the date he fatally refused to even see the father / respondent in this
Who has
fact.
filed this DNWC?
The grandparents and the
Uncle.
uncle,
Hmm.
they have filed, I have filed this application.
And the boy is staying with whom?
Their grandparents.
Visitation is sought by?
Fathers, start by the father. Only visitation, second Saturday, and
Where is the father staying? Where are the grandparents staying?
father staying in Anantapur. He is the school teacher. He is residing over there. The grandparents, they are residing in Bangalore.
Hmm.
And they're taking forcibly custody of this child when he was in JC. There is an allegation that he killed the wife.
How old is he? The boy?
At
Now
present, 11,
11 years.
11 year, 5 months.
When the mother died?
In the year 2017,
17.
4 year, my lord. 5, I think 5 year, my lord.
Right from that time, he is staying with the grandparents.
Yes,
Yes.
madam. After death of her mother, his mother, he is staying with grandparents.
Hmm. How she died?
Father, child identify the scenario of the murder that his father hit her mother with the iron blade attached with stick.
Hmm. What has happened to the criminal case?
It is acquitted.
Acquitted, my lord.
After lapse of 6-7 days, they filed false case. The entire scenario, they have not filed at the time. When she was admitted in hospital, then she passed away. The charge sheet filed by the police.
So, right from that day, the father had never seen the child.
Never seen. They are not allowed. They are taken from Anantapur. They came to the Bangalore. And they filed GMWCT for the custody, entire custody. I have filed the application for the visitation rights second Saturday and Sunday. I have not married. The entire property and other amounts I have to give my son only. I sought for only a visitation rights second Saturday and Sunday only. That also only one ground, Your Lordship kindly see. The now I read on 14th page the order, trial court order in page 25. In the facts and the circumstance of the hand, I proceed to hold that the child ward cannot be compelled to visit his father, and child cannot be subject to the for father trust, taruma, agony, and when already lost his mother, young age, compelling the child to visit his father may make child to remind the incident took place in 2017 again.
The grandparents should make some effort.
My entire property, I will give him my.
Please wait,
Please.
please.
I may be permitted to page number 60 of
Page number 16.
It's the judgment. Para number 22 of page number 60. Para
This
number,
order is only
Yes, my lord.
interim
No,
maintenance.
it's only 13 paragraphs.
But
No, no.
the findings, I need to convince
Which
the
you
court.
want to, which order?
I have produced a judge.
Please wait, let him submit.
It's a order passed by us, order passed in session case number 207.
That, where is that? Where is it? Which page number?
Page number 60 at para number 22, my lord.
Yes,
Para number 22. I may be permitted to read, my lord.
yes.
At this juncture, it is relevant to consider consider evidence of PW8 who is son of the deceased and A1 as according to the prosecution, PW8 is only eyewitness to the incident. His statement was recorded by learned magistrate who is examined as PW14 under section 161 of CRPC. When PW8 came to court, give evidence by the boy stated that the accused scolded his mother and A1 beat his mother from behind his mother with a stick that has a blade. Blade was oozing out thereafter. And page number. One second. And next I may be permitted to read page number 14 of the order, my lord.
Yes,
Yes, my lord.
yes,
Eighth line, my lord.
yes.
They preferred appeal before the Honorable High Court of Andhra Pradesh in Amaravati in criminal number appeal number 380 of 22. And it is pending disposal, and it is still pending for disposal. The respondent filed,
Grandparents have filed an appeal against
yes,
secretary.
I have preferred an appeal. In Andhra Pradesh also, the father filed a GNWC custody petition seeking custody of the minor child. In that case also, the child was interrogated, but the child was refused to meet his father. Again, in this case also, the court has interrogated with the child. Child again refused to go with his father. Child is a brilliant student, and after death of her mother, father tried to strangulate the minor child. I have furnished the photographs which is furnished at my objection at annexure R7, my lord. This is the photograph. Father tried to kill his son. The strangulation marks are there. Both the trial courts in Andhra Pradesh and also in this case also interacted with the child personally. Both in both times also child is refused to go with his father. He is in a fear. He is a merit student, my lord.
I'll make submission. Here, there is no interaction with the child by the trial court judge. My learned friend making false allegation. There is no such. Now, Your Lordship, kindly come to the acquittal,
Check with the boy and then we'll take a call. Not a case for any order now.
please.
The trial court had dismissed the application filed by the father seeking visitation. Then counsel for the respondent submits that the boy is not interested to see the father as he has been an eyewitness with the incident where the mother had lost her life. Considering all this court deems it appropriate to interact with the child. Pose this matter on 22nd of October at 2:30, at
Please.
2 o'clock in the chambers.
Yes, my lord.
The grandparents, father and the child shall be present before the court. Yes, next.
Cell number 14.
My lord, in
and
this
then
case,
The appearance of the petitioner.
I received the copy yesterday, my lord. I seek instruction and
My lords, on the last date of occasion, my lords had directed me to give the list of the fee receipts that I've paid, the fees that I've paid towards the children's expenses. I filed a memo to that effect yesterday, served a copy on them yesterday.
Request of non-counsel respondent. Pose this matter on 22nd October. Interim order is there.
Interim orders there.
Interim order earlier granted is extended till then. Yes, please.
Please.
Number
Obliged.
15, Ms. Swami Gowda, SG. For petitioner, Arun Govind.
As directed, I'm placing the CCTV footage, also some photographs.
So as per the same what it is.
My lord, only I've given the timings also, my lord, I've produced the photographs. I have not taken the child outside.
I have the video recording.
I have produced the entire CCTV footage with the pen drive itself.
Direction was to me to place the material on record. Lordship's permission. Copy. Page 8 is a letter of the developer issued in the year 2020. But there are two separate apartment premises. May I read page 8? This is about the developer in the year 2020. Clarification regarding Prestige Misty Towers and Misty Towers Vista Tower. The purpose of this letter is to provide clarification regarding the right of way reserved in clause 6.15 of the sale deeds executed by us in favor of the purchasers of apartments in Prestige Misty Towers. Kindly note that the said right of way is reserved solely for Prestige Misty Towers Vista Tower being developed on land bearing old 7 number so and so, Yelahanka Hubli, Bangalore North Taluk, measuring 2 acres. Other than the right of way in favor of occupiers of Prestige Misty Towers Vista Tower, there are no other common amenities between these two developments, and the right of way is reserved only through the existing driveway within Prestige Misty Towers to reach Misty Towers Vista Tower. My lord, he took the children away from Misty Towers to that Vista Tower. This is what your lordship's order was very clear. He has to stay within the area of Misty Towers. He took the children to the adjoining complex, my lord. Therefore, I had made that submission on the last occasion. Well, that is very clear from the CCTV footage. I have shown where he's driving out of the Misty Towers complex. But be that as it may, my lord, now the visitation is going on by and far. I think children are more or less comfortable. They have their good days and bad days. They're 3 years old. Therefore, your lordship may make some arrangement, my lord, for visitation on the weekends in such a way that since both are professionals, mother also gets time with the
Sir, I
father.
have produced my photographs and the video, this thing, my lord. My lord, for both the towers, my lord, it's only one entry and exit. For both, that is the reason I produced the plan also. Entry and exit for both this thing, it's only one.
Sorry, it's not
There
entry
is-
and exit. It's right of way. It's like, no, it's like an
Ew, why
Easement.
should it be made a big issue?
it, wa-
It's within the premises.
no, it's not. It is not. No, it's, no,
Anyhow,
easy-
it is like,
Very well,
they're very much within the.
well, that is why I said in the heat of the moment.
If you have to have a drive, it'll cover more area so that they can have the children will enjoy the drive.
At that time, your lordship's order was very specific that it has to be in the Misty Towers comp. That is all. Now,
The whole problem is being too specific, everything is causing the problems. Let
No,
them be little.
now I think we
They thought that the thought should be more, should have a broader thinking.
broader vision. Let us look at the children's welfare and then not proceed. I have.
I think already like they've been before the courts and it's high time that they should stop coming to the court with all these kind
Yes.
of, the grounds which are not at all no need to consider this in fact.
Outside the court, even from the last date, we have been making hectic efforts, not through a senior advocate who knows both the parties to settle the matter. Unfortunately, my other side is uncooperative. Unfortunately, this is communicated to me by the senior advocate.
Why is it not
My
working
lord, let
out?
me see. My lord, according to them, she has to go out of country and she wants to take the children out of the
I have
country.
never said that.
That is what my client has told me.
Never said that. Your lordship, I record my
Who
submission.
has mediated this matter?
Senior advocate, my lord, don't sir.
Okay.
Yes.
And reduce the visitation, which I'm not, my client
No, I
is
have
not
not.
agree with.
Lord, what we have said is, your lordship's order is very specific on educational expenses, on maintenance, and also the sale of the apartment. We are okay with that. We're not claiming any alimony. What we have said that whatever visitation is order is passed by your lordship, let that continue until the children are 5 years old. They're 3 years old now, twins. At 5 years old, let's revisit and enhance it when children are get more. He wants not overnight at this age.
We are not asking overnight, my lord. Even my prayer itself is very specific. On alternate Saturday and Sundays, I'll take the children from 10 o'clock to 5 o'clock. I'll drop the children.
I'm sorry.
That's all.
That
That is what in my
the
prayer.
It sounds so simple, then why it is not happening?
senior advocates communicated to me directly that the other side is not cooperating because they're asking for 50% vacations and overnight visitation. That is where the entire settlement has.
What do you say about
Kindly
it?
record this submission. I will ask the senior advocate to mediate again. Kindly record this submission.
That this visitation, this thing I didn't know, my lord. What was involved to me is that she wants to go out of country, which she wants to take the
That
children.
they are saying that it is not
It's
the
not
issue
the
at all.
Well,
Take you on vacation, not permanently.
Hmm.
Reduce visitation and reduce money. That's what it was informed to him. Whatever the permanent alimony she has asked, reduce the amount what is supposed to be paid by the husband to the wife.
Hmm.
And
If he
also,
wants that to be reduced.
no, no, no,
Huh?
no, that what was informed by the senior counsel to my client.
Hmm.
You consider this and reduce the visitation
No,
rates.
why don't these people appear before the Bangalore mediation
It's
center?
not mediation.
Or,
we've got
or
three
we'll ask the senior advocates.
Mr.
Sheila-
Sheila.
Yes, madam,
Very
we are ready to go for that settlement, that we are not problem.
No, because when the issue is very simple.
I'm
and
not
at
claiming
least-
alimony.
Uh,
I don't know why my learned friend is saying that pay some, we are not claiming alimony. What your lordships has, your lordships order, we have accepted that wholeheartedly. Not, the visitation is where the entire issue is now stuck at.
Now, what is the visitation now?
50% of vacations and
No,
overnight.
As of now, by the order of the court,
So no, your lordships have given 2 hours Saturday, Sunday.
every week.
No, 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 my lord, what is that is what the trial court has passed. That is what I have challenged before
Trial
this
courts,
court.
they have 2 hours once a week.
No, what is the order of this court?
My lord, this court, there is no interim order, my lord.
Hmm.
Your lordship has directed for a week. Let the father go and meet the children from for 4 to 6 or something.
Hmm.
That 1 week he had, that's all.
Hmm.
After that, whatever the trial court has passed, my lord, every Saturday or Sunday after alternate weekends, my lord, about 4 to 6 every Saturday, 4 to 6 he is going and meeting the children. Apart from that, what my prayer is that, my lord, he'll take the children from 10 alternate weekends, that is Saturday and Sunday, from 10 to 5, and then he'll drop back the children. Let that arrangement be made by this honorable court, my lord, I have no problem.
Annexure J, page 89, my lord, the claim before the family court is for 4 hours visitation on one Saturday, or every Saturday. I don't know how my learned friend, my lord, coming before the High Court wants to go beyond the scope of his
That time
claim
the
before the
children-
family court, 227 proceeding.
That time the children were 2.5 years, now the children
I'm
are 3
sorry.
and a half years.
This was filed on 23rd of April 2024, 4 months ago. No, but there may be some fairness in making submissions.
That's what, my lord, 10 to 5 I'm asking. I'm not asking alternate weekends.
You are questioning an order passed by the trial court.
Yes, my lord.
Whatever you ask there,
Yes,
you
my
have
lord.
to stick
Yeah,
to that.
at least that much we begin.
You cannot ask beyond that.
Yes, ma'am.
What was that you asked before the trial court?
My lord, I've asked for the trial court before the application is that, my lord, if your lordship may kindly take that page number 58.
Page number?
58, Annexure C. Please to grant interim custody of the alternative visitation rights of the minor children, Ira and Raghav, to the petitioner during weekend and holidays in the interest of justice. That's what I've asked.
Page 89, my lord.
And thereafter, in the written arguments, what it has been stated, my friend is stating.
That is the case. That's the case made out in the written arguments, page 89, my lord. The
During
petition-
every weekend and holidays in the interest of justice and equity. That's
Yes.
what is the
Kindly see page 89.
18 in the written arguments, my lord,
Written
considering
argument filed by
the age
petitioner.
of the children,
Hmm.
Paragraph number 2, the present 2 hours granted in the park area with the respondent resides is not feasible. And since
No,
children-
what is happening is, please understand, now in their way, in their very own, in their building, all the time, somebody or the other with a phone, we are
ಮ್ಯೂಟ್ ಆಗಿದೆಯಾ? ವಾಯ್ಸ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
that the entry and exit is one and the same to both the apartments. At this stage, this court is is not inclined to go into all those issues. Both the children are now aged 3.5 years. Aged 3.5 years. The trial court's order is that the father can exercise the visitation at the mother's place, between 4 and 6. The children who are of that age, making them to sit at one place and exercising the visitation is of no consequence, no, is not at all useful for the child to develop the bonding with for the children to develop bonding with the father. It is, a request is made by the land council for the father that on a Saturday, on every Saturday, the father may be permitted to take the children to his house, and they can have can exercise the visitation between 10 o'clock to 2 o'clock. And it is also submitted that during the birthdays of the father and the children, and also on vacation and on festivals, in addition to the Saturdays, the father may be permitted to exercise the visitation. Land counsel appearing for the respondent submits that when they have filed a writ petition questioning an order passed with the court, now what all they are submitting before this court is beyond the scope of this writ petition. And what they are seeking is also what they have sought before what they have not sought before the family court. It is submitted that the client, the respondent mother is not coming in the way of the father. And whenever, for any reason, if the father is not able to exercise the visitation, when she is asking him to, when she wanted to compensate the same, even on that also, there is no consensus. And the respondent for the petitioner father says that he'll only exercise the visitation in the weekend, considering the submission on behalf of both the parties, and also considering the welfare of the minor children and the bonding that has to be developed between the father and the children who are of tender age. This court is passing the following order. 1, the father on Saturdays can pick up the children at 2 o'clock and drop them back at 10 o'clock and drop them back by 2 p.m. The father shall stick to the timeline, and on time he has to pick up the children and drop them back. The mother shall furnish the details of the children's food and other habits so that the father would be following the same. While the children are with the father, whatever is the life or the food habits or the other lifestyle which they are used to with the mother, the same shall be followed by the father. Next, on the birthday of the children, as well on the birthday of the father can have first on birthday of the children, the father can take the children at 10 o'clock and that day you can have 2 hours on the birthday.
If it's a school day, then it becomes difficult. in the morning.
If it is a school days, evening I'll take by 4 o'clock.
4 to 6.
4 to 6. If it is a working day, if it's a school day, if the school is working on the day, then it is between 4 and 6. And if it is a holiday, then it is between 10 and 12.
Public.
Even the same has to be followed on all the important festivals. Then coming to the vacation,
Festivals, let it be between 10 to 4, my lord.
Huh?
10 to 2.
for what?
Festivals.
She also has to celebrate.
Because again,
He
traveling
also
itself,
has to celebrate.
Both the
correct, my
celebrations.
lord, because the traveling itself, it takes the,
No, you can't afford to ask for all this because that's not
no,
what
at
is
least, my
the,
lord, off of the day, let the children be with
The
her.
Arab and the camel story.
The off of the day, my lord, let it be.
next, when it comes to the vacation, the father can have
Yes.
the the 40% of the 40% of the vacation
But
where
40
you can exercise.
Summer vacation, it will be 3 months, then 40% would mean almost month and a half or something, because her parents stay in Patna and she travels there usually.
Let her go after that.
40%
In
is
the remaining this.
That's what I said. Now the court will not pass any order
Yes.
because that's
No, madam.
not the
Sorry.
scope of this petition at all.
Sorry,
So
madam.
whatever, the respondent counsel says accordingly will pass an order. Yes,
maybe about 2 weeks, not to start with,
Huh.
during summer
The-
vacations.
during the summer vacation, the father for a continuous period, for a 2 weeks time, as per the, Mr. Govindaraj?
Yes.
Like how it is, like on the first 2 weeks or last 2 weeks?
Let them know,
Let both of, no, if both of them can decide, they would have not been
First
before
2
the
weeks.
court.
first 2 weeks.
Yes, first, in the summer vacation, for the first 2 weeks, the father can have can exercise the visitation between, it's somewhere between 10 and 2. Why can't we'll make it 4 on in the
Yes, ma'am.
summer, only in the summer vacation between 10 o'clock to 4 o'clock. The father can pick up the child at 10 o'clock and drop him back at 4 o'clock. He can exercise the visitation for like this in summer.
Monday
At the
to,
first
Monday to Friday, for the first 2 weeks.
Ah,
So the
for-
Saturday, Sunday,
yes,
mother
yes.
can.
Monday to Friday for the first 2 weeks. Then everything is covered now.
My lord, no,
The father, both the parties shall not, till the father shall not come up with applications, shall not file any application till the children are 5 years old. If this arrangement is not working out and for that, is there any, if any of the parties are not cooperating or not complying, then they can move an appropriate application.
my lord, only the Christmas vacation and the Dasara vacations have not been done.
No,
Only
we-
the,
4 days, 3 days. What? my lord, we-
Dasara vacation, how many days are the vacation? 4 days?
it will be 15 days, my lord, total.
Huh?
School
First to
will be
12th, they
15.
have holidays.
First to 12th.
So four-
For the 4 days in Dasara vacation, Christmas vacation, 4 days. It should be, we'll say that in the first quarter,
Yes,
the immediate vacation.
Yes.
So that after that she can have the time.
Correct.
Yes,
No, if she's traveling out of town already pre-booked.
whenever it is not convenient to the mother, she shall inform the
Correct.
same in advance to to the father. And she shall compensate the same
Correct.
at a later point of time.
Obliged.
Even in case of the husband also, he
Whatever.
shall inform the same to the mother in advance. Yes. Next,
Cell number 16, Mediation Kapoor, for petitioner, Ajar for respondent.
yes.
I wrote the copy, my lord.
Then what about Mr. Gorindraj? The parties shall,
Mediation.
it appears that there is a scope for mediation. Both the parties shall appear before the senior counsel, Susila. Then you can inform her,
I will communicate.
they can appear before her and appear before her. Yes.
my lord, one more submission, my lord. Last date of hearing, your lordship had directed them to furnish the details that the father's name and phone
My
number.
memo, I've already filed the email not
included
even
in
3
the-
months ago.
No, last time it has been directed to them.
In the
Last-
memo filed
So they have
today,
given already.
copies given, sir.
No, it is not. That's what he is not receiving
please
any
see the
messages
email,
from the WhatsApp.
Please see the email.
WhatsApp is asking.
Please write to the school, you have the email ID.
It is submitted, no, it is in the arguments, it is submitted by the council for the, it is a case of, it is submitted by the land council for the father that he is not added in the school group, which is denied by the land council for the respondent stating that they have already added the petition, the husband in the school group. If it is not, the mother shall ensure that the father's,
He has to communicate with the school. I've already given the school all his details. He can communicate. He's been writing to the school.
the mother, it is submitted that
Yes.
the mother has already communicated
Yes.
and the father can be in touch with the school authorities.
Right.
Yes.
16, Mediation Kapoor, for petitioner, Raja for respondent.
I wrote the copy, my lord.
Apply for respondent, my lord,
Hmm.
in this case.
Hmm.
That-
What is the impugned order?
Impugned order at page number 123, my lord. At the interim
123.
maintenance rupees 4,000 to the wife, my lord.
What is your what is your income?
He is a retired employee, my lord. 30,000 is the salary, my lord.
13.
Yes, sir.
Ah.
30,000, madam.
30.
The date of the marriage is, my lord,
No, 30.
30, madam.
Then what is the difficulty to pay 4,000?
My lord, kindly, date of the marriage is 35/1994, my lord. In the 2002, from they are disputed between both the husband and wife, my lord. She filed a criminal miss number 97 of 2003. Wife, 2 daughters, my lord. It is at page number 29, my lord, order. 1,500 is granted to the both the daughters, my lord. And the wife is not entitled for any maintenance. That is the order, my lord. In the 2003, kindly peruse the page number 29, my lord.
Why she is not entitled?
She is working, my lord.
No, she is working at that point of time.
As
No, another application is filed stating that she is in need of money.
Madam-
So just because an order is passed at that time, you can't say that she is not entitled.
One
now.
minute, my lord. Thereafter, my lord, in the 17/4/2002, the husband is gifted the property, my lord. She is in the possession of the property. Thereafter, they filed the RPFC number 22/2011, my lord, for enhancement of the maintenance, my lord, before this honorable court. Honorable court enhanced the maintenance to 1,500 to 5,000, my lord, with a liberty to approach the trial court wherever the enhancement is required, my lord.
No, they have
Thereafter,
approached.
my lord, thereafter also, my lord, as per Annexure C, my lord, C miss number 429 of 2016 is filed. In that, my lord, 12,000 is granted each to the daughters, my lord. Thereafter, my lord, RPFC number 82/2018 is filed, my lord, 12,000 reduced to 10,000, my lord. Thereafter, my lord, the husband is paying the maintenance towards the daughters, my lord. The order in C miss number 97/2000 till date not challenged, my lord. And also in the RPFC number 22 also, if it is challenged, my lord, this honorable come to conclusion that she is not entitled for maintenance, my lord.
No, what are you
Thereafter, my
saying?
lord,
If she had challenged, that would have been an order.
RPFC. Yes, my lord. Yes,
You are anticipating that that would be the order.
my lord. She's challenged, man.
Where is that?
22, man. RPFC
Page number?
number 31, my lord. 31, she is also petitioner number 1, my lord. Petition number 2 and 3 are the daughters, my lord.
Where is that? The court said that she's not entitled for maintenance.
Learned counsel appearing for the response submit that the respondent will pay the entire arrears of maintenance payable to the petitioner to once in 3 installments within 3 months today. The submission placed on the revision petition shall disposed of in the above terms in modification of the order impugned herein.
I'm not able to understand that from this order, what you're submitting. I'm not able to understand what you're submitting from this order.
My
That
lord,
Where
this-
did the court
this
say that she's not
RPFC
entitled?
is filed challenging the orders in C miss number 97 of 2003.
We'll
madam.
have it after vacation. Pose this matter
My
after
lord,
vacation.
my lord, I make one submission. Kindly vacate the stay order, my lord. Only 4,000 was awarded. Yes,
Let's see.
visited this time court stating that he is paying the maintenance to the
Then
daughters.
we'll have it on first, not today. Yes, force is marked on first.
Interim order kindly extended.
Interim order early granted is extended till then. Yes, next.
There number 17.
My lord, I represent the first respondent in both the appeals.
This case,
Yes.
brother, there are two appeals. Arise out of common orders passed on IA number 1, 217, madam.
IA number?
IA number 1,
Hmm.
IA number 2,
Hmm.
and IA number 7.
There is
Well-
only two appeals before this court.
Yes, madam.
Arising out of IA number?
IA number 1, under 39, 1 and 2. IA number 2, under 39, 1 and 2, filed by the first respondent plaintiff in OS number 4832/15. Then, my lord, in the same case, said case, the appellant herein being defendant number 5, filed an application under 39, 1 and 2, seeking an injunction against the plaintiff first respondent herein.
No, before we go into that, MFA 5532, what is IA?
That is
Against
IA number
IA
7, madam.
2,
IA number?
IA number 7
Hmm.
and 5531, my lord, it is IA number 2. And so far as IA number 1 is concerned, my lord, there is no challenge.
We have
Yes.
considered not to alienate.
You have considered, yes.
Yes, ma'am. Now,
Please come to the order.
MFA 5531, madam.
55, 30,
31.
give that one. Yes,
It is, my lord, seeking setting aside the impugn order passed by the Honorable Trial Court dated 5/4/2017 on IA number 2, my lord,
yes,
and seeking dismissal of IA number 2 by the defendant number 5 appellant hearing. Where, my lord, the gist of the facts is that the second respondent with the first dependent in the shed suit, she was allotted a BDA small site, my lord, on 26/12/77. Then, my lord, BDA entered into lease cum sale agreement in her favor on 23/7/1980.
yes,
Then, my lord, on 29/4/2015, BDA executed an absolute sale deed in favor of dependent number 2, dependent number 1, respondent number 2. Then, my lord, the plaintiff, the first respondent herein, who alleged to be entered into a sale agreement, GP and affidavit on 11/7/1994, where, my lord, second respondent being first dependent, Alati, she was not at all having any right to enter into any contract in terms of the lease cum sale agreement. Then, my lord, both parties kept quiet, kept mum for long period.
you are the owner of the property, defendant number 1.
Yes, my lord. Dependent number 1 was the Alati from the BDA, and she was got the sale deed on, my lord, 4/5/2015.
Hmm. Yes,
Then, my lord, she got executed the sale deed in favor of appellant hearing on 4/5/2015 for consideration. As, my lord, the first respondent plaintiff, my lord, he has not paid the sale consideration to the first dependent and her children.
Hmm.
And thereby, my lord, the fifth dependent herein with the appellant herein, who paid the rest of the balance consideration to the BDA and got the sale deed in favor of the Alati. Then, considering the same, my lord, the Alati, the first dependent / respondent number 2, got executed the registered sale deed on 4/5/15. In that sale deed, my lord, she passes symbolic and constructive portion in favor of the appellant herein. The thing is, my lord, the first respondent plaintiff contending that I was put in possession on 11/7/1994 under the sale agreement, and the respondents 2 to 4 have executed the registered sale, GPA and affidavit, and thereby is in possession.
Hmm.
Then, my lord, after I purchased the property, my lord,
Hmm.
the plaintiff has filed the suit in OS number 4832/2015 on the file of the Honorable Judicial 7th.
So as on the day when you purchase the property, the plaintiff is in possession of the property according to you.
Plaintiff was in possession. He was collecting the rents on behalf of the
And
respondent number 2.
he's also residing in one of the floors.
Yes, my lord. It is not in dispute also, my lord. Then, my lord, he filed the suit for performance of the contract against all the dependents, 1 to 5, including me. I am the 5th dependent.
Hmm. Hmm.
Then, my lord, he filed the 2 applications. One is for not to alienate the suit scheduled property. Another one is not to interfere. Wherein, my lord, I appeared before the court and I considered I will not alienate the property during
That's
pendency
IA
of the
number
suit.
1.
Yes, my lord.
Yes.
Then, my lord, I have also filed an application because
Seeking injunction against it.
injunction against the plaintiff,
Hmm.
he shall not come into it to take possession from the tenants.
Hmm.
Then, my lord, I have filed an HRC petition
Hmm.
before the Honorable Small Cause Judge at Mehal
Hmm.
in HRC number 10,024/16, wherein, my lord, the plaintiff, he desires to implead himself as one of the respondent. The Honorable Small Cause Judge was pleased to dismiss the impleading application. Then, my lord, the said petition came to be decreed against the,
Now, in his suit, you can seek injunction.
yes, my lord.
Yes.
Thus, my lord, after filing of the objections and counter objections, my lord, the honorable trial judge was pleased to heard the matter in length. Then, my lord, I would
That,
like to take my lordship to findings
Even judgment. Okay, not to go.
in ink page
If you can maintain
30
an
minutes.
Injunction.
Para 16,
Defendants, plaintiffs, defendant. Yes,
para 16 minutes.
yes, yes.
Short point involved minute. The learned judge come to conclusion that plaintiff is in portion in respect of suit property by virtue of the sale agreement as he has collected the rents on behalf of the respondent number
No,
two.
it is like this. First is, IA number one is not to alienate.
Yes, madam.
That you have filed your, then
Yes, ma'am.
second is, your IA inject, what should be done? How we should be, what is the injunction you are seeking?
I am seeking not to interfere, to take portion from the tenants.
Hmm.
Because I got filed the HRC suit
Hmm.
and I got in the suits,
This is IA number three,
I am number 7,
IA number 7.
7.
Court has dismissed it.
You, yes, madam.
Hmm.
Allowed 2 applications of the plaintiff and dismissed my application number 7. I would like to take my lordship to ink page 30, as
No.
16, madam.
As of now, he is in possession of the property. According to him, he is entitled for the specific performance.
Yes, ma'am.
Unless and until that is decided by a full-fledged trial.
Complaint. Yes,
How
ma'am.
can you ask for injunction? Restraining him from interfering where
That's
he is
what-
in position.
That's what happened, my lord. Now the matter now shut down for further class of PW1. PW2 to 4 has been fully cross-examined. The rest
By the
of,
suit of 2015 will direct the trial court to dispose of the matter.
yes, please, madam.
Yes, please come. Agreed with the orders passed in. I number 2 and I number 7 dated 5/4/2017. The defendant number 5
Yes, madam.
is before this court. The respondent, the first respondent herein, who is the plaintiff in the suit, had filed, OS number 4, had filed the suit speaking specific performance of an agreement
Dated 11/7/1994.
seeking specific performance of an agreement of sale dated 11/7/1994. It is the case of the plaintiff that he has entered into an agreement with the first defendant. And he,
Agreements with the defendants 1 to 4.
1 to 4.
1 to 4.
1 to 4. And they've executed a lease come lease come sale agreement. And they have put in, the plaintiff is put in possession of the property and the defendants have released the entire sale consideration. As per the agreement, the defendants 1 to 4 were required to pay provisional installments every month apart from provisional service charges to the authority. A Solicitor General Power of Attorney dated 11/7/1994 was executed. And ever since, the plaintiff and his family members have been in possession of the property. Even prior to that agreement also, another agreement of sale was executed by the very same defendants 1 to 4 in favor of the plaintiff in respect to the property, and the same has merged with the present agreement of sale. The plaintiff has been paying the taxes in respect to the property. It was understood between the parties that the time was never the essence of the contract. The building consists of 3 floors. That is ground, first and the second floor. In the ground floor, there is one residential unit and one a commercial shop unit, and each of the said units have been provided with separate electricity connection. And there is a tenant in the said premises and has been paying monthly rent to the plaintiff. In the first floor, the plaintiff used to reside along with his family members, and subsequent to the plaintiff shifting to the second floor, the first floor portion has been let out to letted to another tenant. In all, there are as many as 4 electricity meters, and each of the respective occupants have been paying monthly consumption charges to the respective department. Except the second floor where the plaintiff is occupying. All the other tenements have been let out on rent by the plaintiff. In spite of having the entire sale consideration, the defendants have not executed the sale deed in favor of the plaintiff. And whenever he asked them, they were assuring that they will execute the sale deed. During January 2015, the plaintiff had visited the office of the Bangalore Development Authority, inquired regarding the status of the sale deed to be executed by them in favor of the plaintiff. And the plaintiff was informed that steps are not taken to execute the sale deed. However, on 15/5/2015, the fifth defendant appeared near the property and started claiming that he has become the owner of the property and that the plaintiff and his tenant should hand over the portion of the property to him. Thereafter, the plaintiff had come up with the present suit. Initially, what was the injunction that is granted initially, IA number 1?
Not to alienate.
Not relevant.
Initially, the court had, the IA number 1 is allowed, and the court had passed an order not to alienate. Thereafter, the defendants have filed their written statements. Defendant number 5 had, in whose favor the defendants won, whose favor a sale deed is executed, has undertaken before the court that he will not alienate the property. Then coming to IA number 7, that is filed by the defendant seeking a
Given a five
defendant number
operating.
5. What is that? Where is that IA? Page number?
IA not produced.
IA number 7 is filed.
Yeah, that's sought against the plaintiff, restraining the plaintiff from taking possession of the ground floor and first floor of SSP.
IA number 7 is filed, restraining the defendant, restraining the plaintiff from taking possession of
Ground and first floor.
ground and first floor. The trial court had made the injunction absolute in favor of the plaintiff. And when it comes to the IA number 7, the court had dismissed the same while passing while rejecting the application of the defendant. The court observed that the fifth defendant has only constructive possession of the property and has to recover the physical portion under due process of law from the plaintiff. Since the fifth defendant has no physical portion of the suit scheduled property, question of granting an order of temporary injunction in his favor with respect to the ground floor and first floor portion of the property does not arise. If an order of temporary injunction is granted, there are possibilities of the defendants further alienating the suit property. This will cause unnecessary hardship to the plaintiff apart from multiplicity of proceedings, the court felt that there is balance of convenience in favor of the plaintiff, and accordingly, an injunction is granted. The injunction is granted. Aggrieved thereby, the appellant is before this court filing the two appeals, MFA 5532 and MFA number 5531 of 2017. Land counsel for the appellant submits that the defendant 1 to 4 have executed a sale deed and he has been put in constructive possession of the property. Now, he being the owner is entitled to have the possession of the property, and the plaintiff, without any manner of right and title, has been collecting the rents from the defendants as such, from the tenants, as such as filed in IA number 7. Land counsel submits that without any basis, the trial court had dismissed the application filed by the defendant and allowed the application filed by the plaintiff. It is submitted that the court ought to have considered that unless injunction is granted, the plaintiff, the defendant, number 5, would be put to irreparable loss and hardship. Next para. Land counsel, appearing for the respondent plaintiff submits that the plaintiffs or the defendant is also admitting that the plaintiff is in possession of the property. His possession cannot be disturbed, nor there can be an injunction restraining him from there cannot be any injunction restraining him from his peaceful possession and enjoyment of the property. It is submitted that the defendant in his suit cannot seek any injunction without there being any counterclaim. It is submitted that the trial court had rightly considered and dismissed the suit. Dismiss the application filed by the defendant. The next para. This court, having heard the counsels on either side, there is the material on record. The suit is filed seeking the relief of specific performance. Admitted facts in this case are the plaintiff is in possession of the property. It's a case of defendant number 5 that there is a sale deed executed in his favor by defendants 1 to 4, and he has been in constructive possession of the property. And he wants an injunction restraining the plaintiff from interfering with the ground and first floor of the properties. When the defendant himself, for defendant 5, is not in possession of the property, and when the plaintiff is in possession of is in fact in admitted possession of the property, question of granting injunction against the plaintiff will not arise. The trial court had rightly considered the fact and held that the balance of convenience and the irreparable loss are in favor of the plaintiff and not on behalf in favor of the defendant, and that rightly dismissed the application filed by the defendant and allowed the application filed by the plaintiff. And this court finds no reasons to interfere. Next, accordingly, this court is passing the following order. The MFA is MFA number so and so is dismissed. These suits are of the year 2015, and this court deems it appropriate to direct the trial court to dispose of the suits within a period of 6 months from the date of receipt of the copy of the order.
Grateful to the court.
That you keep with you. Yes, next.
Cell number 18. Chantraj KG.
Who moved the memo? They who moved. On the memo moved by the appellant, the matter is listed today. No representation for the appellant. Pose this matter on 22nd of October. Yes, next.
Cell number 19.
This is for admission, trial court record is received.
Mhm.
Therefore, it may be listed on some other day. There is another matter listed in serial number 49 that is adjourned. Therefore, on the same date, it may also be adjourned, seems. Because I have moved this matter, of
No
course.
representation for the for the respondents. Land council for the applicant submits that the already connected matter
It is not
listed at-
admitted.
Huh?
It is not shown as admitted.
Connected matter is,
Not
listed
similar
at-
matter,
huh?
not connected matter, similar matter.
a
at
similar matter is listed at
Serial
item
number
number?
49.
Huh?
Today's listed.
Serial number
Serial number
39,
49.
49.
49.
post along with that.
MFA
on-
six
post
eight
along with
five
that
one.
on 22nd of October.
Which date? Date is given 29/10.
29th is, 29th
29th,
of October. Yes,
Serial number 20. Serial number
The appellant.
For respondent, my lords, in the
Shankar Rao,
morning, we
Vijay
have filed a
Murali.
wakalat. The copy of
today you
it is-
filed.
My lords,
2022 matter,
my lords may have it after vacation, immediately after vacation. we will-
I'll object, my lord. Your lordships recollect, this is the same matter, my lord, which I withdrew last week, my lord, because there's an
Hmm.
earlier. So they're aware, they filed objections.
My lords, it was withdrew on 20.
is an interim order in this?
No, my lord. That's
My lords, there
Look
is
at
no,
it, if it's a case for interim order, we'll grant and adjourn.
Yes,
my lords, there is no interim order, there is no.
all the
urgency,
properties are
henceforth,
the
ma'am.
mother's.
Have this matter right immediately after the
Submitted
vacation,
with the
we'll
land
file our
council for the
details
respondent
objection.
that
to
they have
this.
filed the wakalat yesterday,
My lords, today morning.
today
they have filed.
morning, they have filed the wakalat.
And the copy of was served day before yesterday along with.
The copy is served a day before.
Friday.
At the request that this is an appeal of 2022. Land council submits that, the stay application has to be considered as an appeal of 2022. As,
My lords, there is no stay
as there is
application.
no
we have been-
urgency now, pose this matter on 28th of October.
Lord, may I request, my lord,
Serial number
before vacation.
No, before vacation, not possible. 28, yes,
serial number
Or-
21.
May I request for immediately after vacation?
14,
Great.
yes.
Serial number 21. Mayana Gowda for petitioner appellant. Harish A.S.
Advocate is not well.
Now, what has happened now, the clients are coming to the High Court and representing as if like this is a trial court.
Even for the first time, even there is.
No, very
practice here-
strange,
There is
yeah.
a practice here. I don't know why their advocates have asked them to appear. Even
No
I don't, I have
representation.
not seen before.
No representation, you have, stays there,
There is an interim order.
there is no representation on behalf of the respondent. No representation on behalf of the respondent. Post this matter after vacation on 29th of October. The interim order earlier granted is extended till the next date of hearing.
Serial number 22. The Chudia for appellant Nitin Prasad.
Actually, they were there that day itself, it seems, but they have not put up that.
Oh, okay.
Yes. Where is the trial court record? The suit. Suit is decreed on 22/1/2010.
Yes. Yes.
I think to understand this, we should only call them who wrote this.
No, I have gone through the impugned order.
Uh-huh.
Till the records are found. Would your lordship kindly have a look at para 10 of the impugned order, page 35, running page 35.
No, you're referring from the,
The current, my MFA.
Huh.
Please take up the MFA.
in
In MFA, page number 35,
page number 35.
35, where your lordships will find para 10 of the impugned order. Lord, in the miscellaneous application which I filed before the trial court had to have examined whether I had a sufficient opportunity. Lord, that is what the law requires, Order 9/230. Please let us see, my lord, whether the trial court has satisfied itself
Yes.
about the sufficiency of the opportunity. In para 10, my lord, there are only two sentences which the trial court says. This court gone through exhibit P2, which is the order sheet. In the order sheet P1 dated 2011-2008, there is an office note that court notice to plaintiff number 1 and 2 served on person and court notice to defendant served on office. After calling out the defendant number 1, his absence was recorded in the order sheet and the court gave direction to the plaintiff to take steps against defendant number 2, which is the union. Here it is important to note that in verification portion in the pleading of this petition, it is verified by Bhaskar Reddy, the defense estate officer, that he is also representing. So right here, the trial court is drifting into the issue of whether Bhaskar Reddy as the defense estate officer had a right to represent the defendant number 2 as well, Union of India. The satisfaction that I was served, D1, that is the defense estate officer, is only found in these two sentences. The office simply says it doesn't refer to any record. But there is no record in which any signature of a competent officer along with the seal of the first defendant is found anywhere in the record. If it was sent through the postal department.
So like in between court has drifted from that and then come to para 11.
Yes, my lord, I'll take your lordship. Then rest of the para 10 is about that issue of the authority of D1 to represent D2. Para 11. As on 17/12/2008, the next calling date in exhibit P1, there is an office note stating that the court notice to advocate for defendants returned, put up with the file. In this regard, this court gone through the cross-examination of PW1 and page number in page number 10, PW1 has admitted that, and then, my lord, I will explain later, and at the bottom in English says, and in the same page of the deposition, he has admitted that they had verified the order sheet of, this all deposition of the party, not of the council, the order sheet of the original suit. Prior to filing of this petition, it is admitted by him that the same council represented in OS number 7613 of 1992 and RFA number 546 of 2001. It is admitted by him after confrontation of the judgment in RFA number 545, which is marked through exhibit R1. In this regard, this court gone through order 3, rule 5. Now, I'll pause here for a moment. What is stated in para 11 is the court has established that it is the same counsel who represented earlier in the 1992 suit as also the RFA. But there is nothing on record to show that that counsel was served. Now, please have a look at why the court is referring to order 3, rule 5. It extracts order 3, rule 5. If I may read rule 5, it says any process served on the pleader who has been duly appointed to act in court for any party or left at the office or ordinary residence of such pleader, and whether the same is for the personal appearance of the party or not, shall be presumed to be duly communicated and made known to the party whom the pleader represents, and unless the court otherwise direct, shall be as effectual for all purposes as the same had been given to or served on the party in person. There is no difficulty with the law. What the law says is, if there is a counsel who is representing a party, if the notice is served on the counsel, it is deemed to have been served on the party. But the question is, does the court satisfy itself that the notice pursuant to the remand was served on the counsel? There is nothing. It simply extracts rule 5. Miller, I'll read the rest of the order. Para 12. Including the above provision as per Karnataka High Court Amendment Act, substituted by so-and-so, and then it refers to substituted provision. Then page 39. Therefore,
Service of court to the petitioners is sufficient service of notice stroke summons as per law itself. Moreover, in the operative portion of R1, it is specifically directed by the Honorable High Court as under. The appeal is allowed, impugned order dated 24/3/2001 passed by so-and-so judge in so-and-so OS is set aside. Matter is remitted to court below for fresh disposal after giving opportunity to both parties to adduce their evidence. The parties are also permitted to produce additional evidence as exhibits. The court below is directed to dispose of the matter within 6 months from so-and-so. Then until here, the court refers to the law, the court refers to the deposition that it was the same counsel, but nowhere it records any finding that the court notice was served on the counsel. If
Para 13.
I will read now, para 13. Therefore, there is a direction for the disposal within 6 months from the date of the receipt of the order. Even though the same counsel appeared in the trial court and appellate court, even after service of court notice, has not come forward to appear before the court to assist the court for speedy disposal. Thereafter also, this court directed the plaintiffs to take steps on defendant number 2. My lord, I'll pause here. Now we are going into defendant number 2. Although it says that notice was served, there is no notice served. The court record says that notice sent to the counsel has returned back. So therefore, my lord, two things. Number one, there is no evidence to show that the court notice was served on first defendant DEO. There is no signature with office seal as an acknowledgement. Number one there. Number two, assuming that Order 3, Rule 5 has to be pressed into service, there is no evidence on record to show that the counsel was served. Of course, the same counsel represented before the Honorable High Court also. But pursuant to the remand, was that counsel served? The answer is no. Then the court drifts into 6 months requirement. Although it says that it is served, there is absolutely no evidence that it refers to. Then it goes into referring to how defendant number 2, Government of India, was served. So therefore, my lord, there is absolutely nothing in this order which shows that D1 was served either directly or through its counsel. Therefore, my lord, this order does not satisfy the requirement of providing sufficient opportunity to me. And on these two grounds alone, it is liable to be set aside and opportunity should be given. Making hazy references to just a bald reference to the law without referring to the actual evidence on record as to how the counsel was served. If the counsel was served, the court should have referred to the document. There is no such reference to the document. And even in para 10, other than the note in the order sheet, which says that the D1, I have gone through that order, it says court notice to defendant returned, it says. And below that it says served on office. Lord, that order sheet dated
Office is referring to D2.
Which one, my lord? No, D1.
D1 only.
D1.
That is dated?
My lord, order sheet dated 20th November, that is 2011-2008.
2011-2000.
If your lordships are looking at the order sheet of OS 7613, in that, kindly turn to order sheet, my lord, on top your lordship will find
You said what is the date?
20th 11. 20th November.
November 2008.
Lord, there it says C/N, that means court notice to plaintiff number 1 and 2 served on person. Below that is where I figure. Court notice to defendant 1. It says RETD should have been returned.
Served on office.
Then it says served on office. So we don't know what exactly it means. If it was served, then my lord,
Probably it is served on office.
served on. For this, my lord, my respected submission is there is no record in the trial court records. There is no evidence of yes, an acknowledgement with the seal and signature of the office of DO is not found.
So this is the only reference with regard to the
Yes.
defendant number 1.
Yes. Defendant number 2, my lord, they have taken out some public notice. My lord,
Then where do you get with regard to this advocate for defendant number 1?
nothing other than the impugned order, there is nowhere else.
Date.
No, the reference is there, but there is no evidence as such.
What other evidence is required?
No, of course there has to be evidence.
So the
One
recording of the
minute, 1 minute. I don't know what my learned friend is submitting. In our language, service means there has to be a document. There has to be an acknowledgement by the counsel. Now, where is that acknowledgement? I have not found in the file. The court should have said, This is the acknowledgement which the council has received. Obviously, any advocate will receive it by affixing his signature, seal of his office, and the date on which he has received. That document is not there in the record. In the absence of that, how did the trial court come to a conclusion that the advocate is served?
2011-2008 endorsement that it is served on the office. For that also, there is no, there's
No.
no acknowledgement.
The seal and signature of the competent officer of the defense estate officer is not there in the record.
I will verify, my lord. I will verify. My briefing counsel says that she has verified in the trial court. It is
No, because
there.
of the entire
It
record
is
is.
there.
No, please verify. I mean,
No, if it's.
Let us not
No,
make any submission
if it is
without
not there,
verifying.
then.
no, no, I'm sorry. I'm making the submission after verifying.
Yes.
The
Let
seal
him-
and
let-
signature is not there. If
let-
you want time, you please verify. But don't say that submission is being without verification. My colleague Chandrachud has seen it twice. Just now, about half an hour back and in the morning.
We will-
Just
and I'm
have a
doing
look
this.
at it.
If he wants to verify, I mean, I have no difficulty with it.
No. Madam, the point is, the judgment was in 2000. The matter was remitted back to the trial court in 2008.
Hmm.
2008,
It was
Ceremony
decreed on 2010.
until 2012, the appellant will not care to go and see what has happened. That itself is negligent.
That is altogether different. My lord, that is an altogether different issue.
No. When is the order passed by the trial court?
By the trial court. my lord.
2010.
That is in the miscellaneous matter.
Miscellaneous matter, my lord, the impugned order?
Hmm.
Impugned order is 25th September 2023. The order which is impugned before my lord is
And MFA is
25th
filed in
September.
2024.
I'm sorry, my lord?
MFA is filed in 2024.
MFA ಯಾವಾಗ file ಮಾಡಿದ್ರು? 28th February 2024. ಆಗಿದೆಯಾ? There was some delay, it is condoned.
It's all right.
5 days delay.
Records speak for themselves. And the Honorable Supreme Court has said.
But unfortunately, right from 2010-11 till 2023, that application is not disposed of.
Yes.
Generally, in all these kind of cases where there is not much delay, who should condone it and dispose of? Should
My
he
lord, I have
depart on
appeared
the
before
merits
Honorable
of it,
Supreme Court in these kind of matters.
No, no, no,
20 years later, their lordships have settled it and said, we give paramount importance to opportunity, full opportunity.
No, what I observed is from this couple of months, as far as Karnataka is concerned, on this Section 5 petitions and on this miscellaneous petitions, little like more technical approach.
Yes.
More technical.
Shouldn't be,
approach.
my lord, but shouldn't be.
Have to-
Parties should be heard on merits.
Correct. How you, we can't lay down the red carpet for you to come to the court.
No,
But
I don't
this-
need any of your carpet.
Not in this case. Generally, like for example, within now,
It is my right to be
within
heard.
even before 30 days, even within 30 days, when an application is filed, showing some reasons, like I can understand if it is inordinate delay. Immediately, if it is filed, it should be because
No, no,
there should be a full and final
Yes, the
settlement.
council also should not object. Madam, now, your lordship will have
You
it,
can
sir.
have a look at the file.
Yeah, we will.
Yes,
Today,
yes, you can.
today or tomorrow, can you see it? Tomorrow?
Because now it is available. In the section, they will not give you
Madam,
to.
we will inspect.
During
the
the course, you can have it.
officer,
During the
but
course,
would your
during the course
lordship
of the
have it
day,
on Monday, madam,
we'll have it.
Monday.
During the course of the
Yes.
day, you can have it,
Yes.
not tomorrow. During the course of the day, the counts for the.
Yeah, my
the
colleague-
Respondent,
Because she has-
respondent is permitted to look at the records and make the submissions on Monday. Heard the council, heard the, yes, in part.
Hmm?
Yes.
Yeah,
Monday.
you can
But-
see it right.
Huh?
Or you can come at 2:30 and. see. Yeah, I can also see. it.
Yes.
Yes.
Cell number 23. Vishwanath
Thanks for,
Shetty.
Palin Pellet. It has been taken after vacation, madam. They are not keeping well.
Hmm.
Gurudat.
No stay? No stay in your favor?
Please there, madam. They have undertaken that they will not participate with the matter before trial court, madam, execution court. madam.
That hundred should not be taken.
He wants after
No,
vacation.
I have no objection until after vacation.
The, at the request of non-council, the appellant
Date
posed
will be
this
given.
matter on 23rd of October and the earlier undertaken given by the, so and so. The order is extended till the next date of hearing.
Much obliged, madam.
23rd.
Number 24.
Much obliged.
24. Muralidhar HM.
Yes,
This is plaintiff's appeal,
yes.
suit for injunction,
Suit for?
suit for injunction.
Huh.
IA number 1 is rejected for temporary injunction.
Mm.
It's rejected. That is how I am before my lords. Plaintiff, that is appellant, is a house building cooperative society.
Appellant is a
House building cooperative society.
society.
Yes. Large extent of land was acquired by the government for public purpose. That is for formation of layout and allotment of sites to its
Mhm.
members. And the layout was formed and the members are allotted site. Everything is over. In the year 2004 or so, certain extent of land was acquired for railways, that is defendant, for expansion of their project, because the railway line runs beside or adjacent to this layout. All right. The acquisition process was over. Certain lands were acquired, possession of which was handed over to them by drawing Mahajar and the sketch. Compensation was not satisfactory. Reference was made, reference was allowed, and the compensation was taken, and they put up their boundary stones also for the acquired area. But they did not do any work for a long time. Nevertheless, the boundary lines were marked. We did not do anything within that. Now, all of a sudden, in the name of expansion of the railway project, they are coming to the land beyond what was acquired. There I objected for the same. They showed before the trial court some joint survey conducted by them saying that additional extent of land is also required for them. Therefore, they are carrying out the work. I said, no problem. You acquire and then come on the property, because we have formed the layout and the lands are provided for civic community area. You can't come on the property on the basis of the joint survey conducted for the purpose of additional requirement. At that stage, I went before the court. The notice was ordered and the railways entered appearance and produced.
What is their case?
Their case is that they are within the area and the only document placed on record was the joint survey conducted by them. My lords, kindly turn to ink.
Joint surveys, that is, you're also present.
No,
Hmm.
I was not present. It was conducted by railways with the land record, the director of land records, that is surveyors. It was not.
When was it before filing the suit?
Before filing the suit, it
Hmm.
was conducted and I was not aware of. Now and they also refer to one order passed by the estate officer under Public Premises Eviction of Unauthorized Occupants Act to say that they have constructed the building and the building is within the acquired area. There is no dispute about it. If it is in the acquired area, we have no say. We are only concerned with the suit schedule property where they are doing some civil works, which is not an acquired area.
Which they are denying.
Which they are denying. Therefore, in the circumstances, a joint survey needs to be conducted and a survey report shall be placed before this honorable court. If it is within the, because extent of land acquired is not in dispute, the sketch is not in dispute, payment of compensation is not in dispute, whether the work they are carrying out is within the acquired area or beyond is the question to be decided.
Will issue notice.
Please, my lords.
Notice to
And
the
may I
respondent.
submit, my lords? During the pendency of the suit, though there was no written order as to the maintenance of status quo or injunction, there was a oral direction by the court not to do anything, not to take precipitative action and go ahead with the work and all that. After that, this order is passed.
We'll have it on reopening day. Post this matter on 14. The counsel for the appellant is permitted to take court notice on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. To that effect by 14, list this matter on 15.
May I submit, my lords? Shall I come back on Monday after serving copy on the other side? Because they are putting up the compound wall on my property. There is some urgency and I am aware that.
Unless they are represented, we cannot in these facts and circumstances. So that's better let it come out.
No, the council representing them will definitely appear. So if I serve
Yes. If you can post on first, by
first,
the time we shall take hand summons on the council appearing for the, by the time post this matter on Monday. By the time the counsel for the petitioner shall take hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. Yes.
Please.
Till number 25. Ramesh.
But I
yes,
appeal for
there-
the appellant in this matter, my lord. In this matter, my lord, the plaintiff has filed the suit for partition, my lord. Partition is filed. And in spite of the interim order passed by the trial court, my lord, the defendant, first defendant has alienated a portion of the property. Thereafter, my lord, I made an application, my lord, under Order 39 Rules 1 and 2 CPC, not to alter the nature of the properties. But the trial court, since the purchaser is not made as a party to the suit, trial court has rejected application. Your lordship the other day heard, and I made a submission, my lord, I may be put in liberty to make such an application, my lord, after impleading the purchaser. That is why, my lord, your lordship directed me to serve the copy on the
I have no objection.
council, my lord. I have done it, my lord.
We'll pass order in the afternoon.
Please.
I represent only the respondent numbers.
We'll see in the afternoon.
Oh, okay.
Yes, get it.